They deleted my fucking evidence online and showed that I couldn't sit there and show. The people that have fucking seen those documents know better, and they're the ones that have caused this political thing for me, huh? Well, fuck you too. 20 years ago. Wah. What you're doing is today, people. You're fucking people today. I fucked somebody 20 years ago. So let's say it's true. Okay, I'm the worst fucking thing on the goddamn planet 20 years ago. You are the fucking worst thing on this planet today. Did you notice something else? There's no waiver in this show. Sue me, bitch. No waiver. No imagination. No ink blot test. You're crap. If you continue this, you are crap. That's the if. That's the only if. Can you learn from your fucking mistakes and start doing the job? You have a CA network that has done nothing since its creation except a logo and have fucking Cop Cam busting his ass making you a program that will never be used.
Here's a clean, legally usable rewrite, followed by a straight assessment of the problems with the plaintiff's story and exposure. I'm not soft-pedaling this. Factual narrative, cleaned and organized. The plaintiff has a documented prior history with the defendant, including prior litigation in which the plaintiff was required to cure deficiencies. The plaintiff has previously attempted to obtain both a temporary restraining order, TRO, and a permanent protection order, PPO, against the defendant. On the date of the courthouse incident, the plaintiff claimed there was a rehearing involving the defendant and asserted that he was not required to attend. Despite this claim, the plaintiff voluntarily attended the rehearing. Upon entering the courtroom, the plaintiff observed the defendant's partner seated approximately 12 feet in front of him. After court recessed, the defendant arrived in the courthouse parking lot and parked his truck in a marked parking space in plain view of the courthouse, facing the building. The defendant remained seated in the vehicle. After the hearing concluded, the defendant's partner exited the courthouse and joined the defendant in the truck, where they discussed the hearing. Approximately 30 minutes later, the plaintiff exited the courthouse and walked along the sidewalk toward the parking lot. At that time, the defendant began to exit the parking space and proceeded toward the parking lot exit. The plaintiff waved his hand and stepped off the sidewalk, following the defendant's truck. The plaintiff had no documents or papers in his hands during this encounter. The plaintiff cupped his hands and shouted, "I won, I won," and then sprinted after the defendant's truck, continuing onto a public street. The plaintiff then returned to his van, executed a U-turn, and followed the defendant's truck. The defendant contacted law enforcement. Officers located both vehicles, observed the plaintiff actively following the defendant, and conducted a traffic stop. During the stop, the plaintiff admitted to police that he knew he should not have followed the defendant. The plaintiff claimed he was attempting to serve a TRO he had just obtained from the court and produced TRO documents identifying himself as the petitioner. Law enforcement advised the plaintiff to return to the courthouse with the paperwork and explain the reason for the stop. The plaintiff was issued a citation for CRS 18911C and informed of the basis for the charge. Additional relevant conduct in admissions weeks prior to the courthouse incident, the plaintiff published a live stream video after allegedly obtaining a PPO against the defendants. In the video, the plaintiff appeared intoxicated and claimed an alarm or noise drew his attention. He stood up, briefly handled what appeared to be a shotgun, set it aside, then brandished a pistol on camera. During the live stream, the plaintiff stated he had no issue shooting you in the groin and made additional threatening remarks, followed by the statement, "Court order or no court order," implying reference to the defendants. The plaintiff is legally prohibited from serving a TRO in which he is the petitioner. Self-service defeats the purpose of a restraining order and is expressly prohibited under Colorado Rules of Civil Procedure. The plaintiff has also claimed that his roommate could serve the TRO. However, such service would likewise be invalid, as the roommate would be subject to the TRO's non-contact restrictions and is not a disinterested third party. The roommate also attempted to obtain a TRO simultaneously with the plaintiff, which was denied. Subsequently, the plaintiff publicly admitted in another live stream that the PPO he previously obtained against the Thayers had been dismissed weeks earlier on appeal. He stated this dismissal was the reason he applied for a new TRO. The plaintiff further claimed the judge failed to sign a waiver of service fees and continued to assert that he was attempting to serve the TRO at the time of the traffic stop. The plaintiff claimed law enforcement refused to serve the TRO and directed him to the sheriff's office. He further claimed he served the TRO via email. Under Colorado law, a petitioner may not serve a TRO. Initial service must be completed by the sheriff, a licensed process server, or an adult non-party to the case. Email service is not a valid method of initial service unless the respondent expressly agrees in writing to waive formal service through a court-approved waiver, typically notarized. No such waiver exists here. Blunt legal assessment, no sugarcoating. 1. The I was serving a TRO defense is dead on arrival. He legally could not serve it. He knew it. He admitted he knew he shouldn't be following the defendant. That admission alone guts any innocent intent claim. 2. This is textbook harassment under CRS, paragraph 18-9-1111C. Following, chasing on foot, pursuing by vehicle, continuing after the defendant leaves, and police witnessing the conduct removes any ambiguity. 3. The firearm livestream is devastating context. Brandishing weapons while intoxicated, issuing violent statements, and explicitly referencing court orders establishes menace, motive, and pattern. Even if not charged separately, it is admissible context for intent and credibility. 4. The plaintiff's credibility is wrecked. Lied or misstated service rules, claimed PPO validity after dismissal, claimed valid service by email, claimed police refusal improperly, contradicted himself across live streams. 5. Attempted TRO abuse is evident. This looks like retaliatory filing after an appellate dismissal, followed by confrontational conduct masquerading as service. 6. The ticket is the least of his problems. This fact pattern supports denial of future protection orders, potential contempt exposure if conditions existed, firearm restriction scrutiny, impeachment in any ongoing or future proceedings. If you want, next steps could include turning this into a sworn affidavit, a motion to dismiss or oppose TRO PPO, a pattern of abuse evidentiary summary, a criminal charging analysis beyond the citation. Say the word.
Well, fuck you too. 20 years ago. Wah! What you're doing is today, people. You're fucking people today. I fucked somebody 20 years ago. So let's say it's true. Okay, I'm the worst fucking thing on the goddamn planet 20 years ago.